Hey everyone, it's Rob Ryder, March 10th, 2013. Lost an hour today, daylight savings time here in America. Uh, this video is really going to be about title insurance, but before we get there, I had to share this because Roe got this on Friday. They were supposed to have a hearing on Thursday for her foreclosure, and so early on we had put in an answer to their complaint. And then just a couple days before the hearing, we put in a précipe. Well, Roe didn't go to the hearing because really they hadn't given proper notice. And to give proper notice, as it turns out, um, if you go look at a court case that's been done properly, right? They put in a motion, they put in a notice of motion, and they put in a certificate of service. Well, you don't normally see the notice of motion in there. And if there is a notice of motion, there also needs to be the motion, and there needs to be a certificate of service. Like three different things have to happen. And if the notice isn't stapled to the motion and sent to you, then you didn't get proper notice. And so a lot of times you'll see the motions in there, you may see a notices in there, but you don't see the other piece of paper. So she had never really gotten proper notice and decided, look, I'm not going to go to court, put in a précipe, we'll just wait and see what happens. And so nobody was in court to hear what transpired to cause this, but this was on, I believe, Thursday of last week. And so the court being fully advised in the premise, it is ordered on the motion of the plaintiff that the cause be continued to 4/18/13, April 18th, for a status call in which the miscellaneous order is the plaintiff is granted 28 days to respond to the affirmative defenses. Well, 28 days doesn't have anything to do with February or April 18th, right? 28 days from March 10th would be April 10th or April 8th, somewhere in there. But the judge is ordering the plaintiff to answer the damn defenses, and those defenses would have been on the original answer, our answer back to their complaint, basically saying, hey, they didn't put it under oath. And people say, well, where does that come from? And, how can you say that and so forth? And, well, let's see what we have here. So, this just happened on Thursday. We'll wait and see. Now, she's also put in a précipe. Normally, after 20 days on a précipe, you can get a notice for default judgment. And so then you go put a notice in with a précipe saying that if they haven't responded in 10 days, you're going to get a default judgment. So what do you do then? Because that's where Bob in Pennsylvania is now. He has a default judgment, non-pros, against the bank and the mortgage company. Right? How many people have got a frickin' judgment against the bank and the mortgage company in a foreclosure? He does. He did it with a précipe. Took 30 days. And that was after the judge had rendered a judgment verdict in the favor of the plaintiff, being the bank, which is all covered on earlier videos. Strange things happen in the courtroom. So, for Bob and Roe and anybody else doing this, I think the next thing that we would do, right now we got the judgment, well, what would they do? They would go get like a writ of attachment or a writ of possession or a writ of garnishment or whatever it is. And you can get one of those with a précipe also. And so I think that's the next thing we do is we petition for a précipe to have either a writ of attachment against all the bank's assets until they pay the bill, basically put a lien against them. That would be the writ of attachment. Or a writ of possession because the judge in Bob's case said that he had jurisdiction over the res, over the subject matter of the dispute. And he issued an in rem judgment, and when you look at the definition of in rem, one of the things it says is that the judge doesn't necessarily believe that the person in possession is the owner. And in this case, the bank or the mortgage company is in possession of like things like the legal title and the securities and the deed of trust and so forth. And so the judge said he issued an in rem judgment, and that's one of the definitions of it. So we just got to learn. All we need to do now is finish the deal. All right, we got the judgment. Let's go issue an order. It ought to be an interesting week. Okay, so there'll be more about this and some other very interesting things that Roe has found out by talking to the county clerk and having access to the records behind the desk of the county clerk, or behind the counter. Interesting things. Interesting. And we'll talk about that on the next video. But what I wanted to show you, so here's this. Now, where does it come from that they have to do something like maybe, swear to their complaint? Well, this is Supreme Court of State of Illinois rules. They got a thing called Rule 113. Requirements of this rule supplement but not replace the requirements set forth in the Illinois mortgage foreclosure laws. So they got a whole other set of laws for foreclosure. Apparently the Supreme Court didn't think that was enough. They decided to add some. Rule 113. Supporting documents for complaints. In addition to the documents listed in section of the other one, 1504, a copy of the note, as it currently exists, including all endorsements, allonges, shall be attached to the mortgage foreclosure complaint at the time of filing. Prove-up affidavits. Requirements of prove-up affidavits. If plaintiff is seeking a judgment of foreclosure under 1506 of the foreclosure law, by default or otherwise, shall be required to submit an affidavit in support of the amount due and owing under the note when they file any motion requesting a judgment of default against a mortgagor or a judgment of foreclosure. So if they're going to ask for a judgment, they have to put in this affidavit. Content of the affidavit. All affidavits submitted in support of entry of judgment of foreclosure, default, or otherwise shall contain at a minimum the following information. This is at a minimum, so I'm not going to read this whole thing, but let's take a look at what they were supposed to put in. This is what it should look like. All right. Affidavit of amounts due and owing. I, somebody, have authority to make statements on behalf of somebody, whether you are a custodian of records, person familiar with the business and its mode of operation, if you are a person familiar with the business and its mode of operation, explaining how you are familiar with the business, and, okay? But look how long this affidavit is they have to put in. And then they have to say what the principal is, the interest is, the pro rata MIP, escrow advance, late charges. Got to list all the charges separately and give you the gross amount due, and then the net amount due, and then do it under oath. I bet you don't find any of these in a foreclosure case going on in Illinois right now. Right? This shit isn't in there. But it has to be, according to this. So what you would do is, if you were in Illinois, you could put in a précipe, issue the Rule 113, Supreme Court of State of Illinois Rule 113, Section C, prove-up affidavits. And tell them to put up the affidavit. If they won't do it, you get a default judgment. But in looking at all that stuff, now this came out of that foreclosure act that they were talking about in the last one, not the Supreme Court rules, but the actual act, and had a list of definitions, and one of them was the guarantor. Means any person who has undertaken to pay any indebtedness or perform any obligation of the mortgagor under the mortgage, or of any other person who owes payment or performance or of other obligations secured by the mortgage, which undertaking is made by guarantee or surety agreement of any kind. that sounds like title insurance. And sure enough, in the Title Insurance Act of Illinois, it says title insurance means insuring, guaranteeing, warranting, or indemnifying owners of real and personal property, or the holders of liens or encumbrances thereon, or others interested therein, against loss or damage suffered by reason of liens, encumbrances, defects, unmarkability of the title to the property, the invalidity and unenforceability of any liens or encumbrances thereon. The title company is your frickin' attorney. Well, they always tell us go hire an attorney. You did. You bought title insurance. That's what it says. Insuring, guaranteeing, and warranting the invalidity or unenforceability of any liens or encumbrances thereon. Where is my attorney? Why are you going to court for foreclosure when you have, by title insurance, they have to defend you? And that led into looking at a bunch of stuff this week. And let's take a look at Bobby's in Arizona. This was, okay, where is it here? I looked at 3 or 4 different title insurance policies, and I'm far from being an expert, right? There's just lots and lots going on that I hadn't even thought of before. But this is Bobby's title insurance policy. Owner's coverage statement. Your insurance is limited by all of the following. And then it starts listing what they are, but I love this one. Our duty to defend against legal actions. Period. It's their duty to defend against legal actions. They don't have a choice. It's their duty to defend against legal actions. Well, what's covered? Someone else owns an interest in your title. Someone else has rights affecting your title arising out of leases, contracts, or options. Someone else claims to have right affecting your title arising out of forgery or impersonation. Someone else has an easement on your land. Someone else has a right to limit your use of land. Your title is defective. These are all covered. Any of the covered risks 1 through 6 occurring after the policy date. Someone else has a lien on your title, including a mortgage, judgment, state, federal lien, special assessment, any kind of lien against your property you have title insurance for. They're supposed to defend you. Someone else claims to have rights affecting your title arising out of fraud, duress, incompetency, or incapacity. You do not have both actual vehicular and pedestrian access. You are forced to correct or remove an existing violation of any covenant, condition, or restriction affecting land, even if the covenant, condition, or restriction is accepted in Schedule B. You are forced to correct or remove. We're going to find that there's lots of errors in these things they're talking about. Okay, so this is this is title insurance, right? This is what the insurance policy says. And out of all of it, the one I like the best is our duty to defend against legal actions. Now, it says it has a Schedule A. It says it has a Schedule B. It's got a page 2. And page 2 and 3. Exclusions are on page 2. Conditions are on page 2 and 3. Schedule A, Schedule B. So let's see what we got on here. This is Schedule B. This policy does not insure against loss or damage, nor against attorney's fees or expenses, any or all of which arise by reason of the following. Right? So if any of these are a reason, they're going to say the policy doesn't cover it. So taxes for the full year 2005. Now pay attention. First half is due October 1st, 2005, and delinquent November 1st, 2005. You had better go pay your general taxes at the tax window in the county clerk's office, not to the treasurer. Go to the tax window, pay your taxes. They're due in October, delinquent November 1st. If they go delinquent, they're going to put a lien against you. The second half is March 1st and delinquent by May. There you got 60 days. Right? When we don't pay our taxes, our lawful taxes, they will put a lien against you. It's called a municipal lien. They're doing it all the time. Special assessment liens. library fine, who knows what it is. They can put a lien on you for anything. And that lien will put a encumbrance against your entire estate. Any charge upon land by reason of its inclusion in the Royal Ranch Homeowners Association. Okay, so says that you're going to be part of a homeowners association. Well, we'll be checking that in just a minute and see what that's all about. Water rights claims of title to water, whether or not shown by the public records. Well, what's that about? If it's not shown by the public record, then it's a statutory lien and it's unconstitutional. It better be on a public record. If it's not a public record, it doesn't exist. Public record is foolproof evidence brought in any court. Used evidence is the evidence. It's the law. Can't be disputed. Certified copy of a public record. Another great thing is an acknowledgement has the same power. And as it turns out, it sounds like evidence you're supposed to hand to the judge in the courtroom. And that was on some other thing reading about evidence. Evidence is given in open court. You know, you put motions into the court case. Kind of interesting. Out of the clerk of the county clerk's office, you get certificates. Out of the Register of Deeds here, you get notices. In court cases, there's motions. And there's notices too. I wonder if they're both courts. Everything's a court. Okay, so this is a list of all the things that aren't supposed to be covered. Now we got these easements, restrictions, conditions, setback, forth, recorded in, got to go to this book and page, some map. And then you got some covenants. They're official records, but deleting any covenant, condition, restriction indicating a preference, limitation, discrimination against race, color, religion, handicap, family status, national origin. Do the effect such covenants, restrictions violate Title 42? Terms and conditions contained in the document some kind of memorandum of agreement that Bob's part of, and that's found in this record right here, 2003-072-8794. The terms and conditions provision contained in a document entitled Party Wall Agreement. Oh, he's part of a party wall agreement. Ain't that cute? I wonder what a party wall is. That's been recorded too. Right, so all these things that don't have your name on it, that have something to do with you or your property, are on the Schedule B. A deed of trust given to secure an indebtedness, dated April something or other, recorded wherever it is, official records, where it says the trustor is Robert Bradford Kirby, the trustee is First American Title Insurance, the beneficiary is Mears. Well, I don't think so. None of those people are on the contract. The deed of trust is between you and the lender. It's just a contract. It's a security agreement. Right? That there's no trustor or there's no trustee on it. There's no beneficiary. It's just a contract. It's a security agreement between you and the bank. Okay. So those are the things he has to watch out for. I may have too many things open here. Close some of these up. So that was that. All right. So what was schedule? This tells you how to make a claim. Prompt notice of your claim. You got to let them know you have a claim. Schedule A. This tells what it was amount, date, deductibles. Got a few deductibles. Name of the insured, Robert B. Kirby and Barbara Haggerty. Now here's the interesting thing. Why is it on your warranty deed they use your middle initial? Right? Because look at this. The title of the estate or interest in land is vested in Robert B. Kirby, also known as aka Robert Bradford Kirby. They're saying that what you would consider your given name with a surname at the end is an assumed name. It's an also known as. That your real name is you with an initial for your middle name. They're saying that's the real person, and they put them on mortgage, or they put them on warranty deeds that way. So if you don't have a license to do business under an assumed name as Robert Bradford Kirby on file with the county, well, you're breaking the law. Also known as, aka. And the land referred to, okay, you got Exhibit A. Okay, now this is that first agreement it talked about. Where was this thing here? Now this gets interesting. We're going to look at what some of these things were. This memorandum of agreement, I think it is. Well, I don't know. But this is an agreement that he's part of between the Unified School District number 89, which is a political subdivision. It's a self-functioning governmental unit of the state of Arizona. It's called the district, right? It's just like the District of Columbia. It's its own government. And, this is saying that basically you're part of that political subdivision. And, okay, so and then this other company who was going to be the developer, and the developer owns certain real property, commonly known as this Royal Ranch, where this used to probably all back then was all open land, and now it's a bunch of houses. More particularly described in Exhibit A, it's the property. Developer intends to develop property as a master plan community. Developer of the property will increase population of students attending school in the district. Difficulty of the district timely require public school sites. Yeah, they gotta have a reason to have this, right? But we're gonna have an agreement. So the district desires financial contribution from the developer to timely acquire public school sites and to construct and or make capital improvements to public school facilities to accommodate the increasing number of students. So for and in consideration of the covenants contained herein, the district and developer intend to be legally bound, state, confirm, and agree as follows. Donation. Developer hereby agrees to pay the district a donation of $300 for each single-family residential unit initially constructed on the property. Donation shall be paid to the district at the address given in 9 within 15 days after the end of each fiscal quarter in the amount of $300 times the number of building permits issued. So it's based on the building permits. You get a building permit, the developer is going to donate $300 to the school district. Well, nothing wrong with that. For purposes of this agreement, okay, just what they are. Notwithstanding anything herein to the contrary, no donation shall be due or payable in connection with any remodeling, expansion, reconstruction, subsequent construction of a dwelling unit on a lot within the property after donation has already been paid. One-time deal. Just need to pay it. And it's what it's going to be used for. Future, the parties acknowledge that developer's contribution of the donations to the district in accordance with the terms and conditions of the agreement fully satisfies any and all obligation of developer to facilitate the acquisition of public school sites, construction, and improve any and all the school facilities within the district, and to address the anticipated impact of the developer's development of the property on the district. Notwithstanding anything herein to the contrary, is at this time in the future, any federal, state, county, municipal, or other government, quasi-government authority with jurisdiction over the property imposes any development fees, impact, dedication requirements, exaction, or similar fee or charge on the property called development fees through the exercise of either its police power or taxing power other than secondary general real estate taxes or secondary real estate taxes. So, right, those aren't included. General obligation bonds, and the school district override election in connection with related to the acquisition, development, construction, and improvement of school facilities in the district. Yeah. Jeepers, let's get to the point. If the development fee for dwelling is greater than the donation for such dwelling, the development fee shall be deemed to satisfy the developer's obligation under Section 2. So it sounds like when you go to get this, when you go to get the building permit, it could be a lot of people got something hanging on there that you would be part of, right? And so the school is going to hold you to $300. But if these other fees are already more than that, then you don't, it's a credit off of the $300 you were going to give them. So what was this all for, right? What's the idea? And then the district represents and warranties. The district represents and warranties to developer, which representation and warranties constitute a material part of the consideration hereunder as follows. The district is a political subdivision of the state of Arizona, duly organized, validly existing, and in good standing under the laws of the state of Arizona. There's something about them being a political subdivision that is either good for us and we should try to use it, or we would just want to get out of it. District has power and authority to enter into and perform its obligations under this agreement. Well, what are their obligations? The execution and delivery of this agreement and performance by the district on its obligations under this act have been authorized by all necessary action. Okay, I don't want to read this whole thing, but it just goes on and on and on, and right. So, point is, Bob is part of this, even though he had nothing to do with the contract. And when he went to get this, so he started out with whatever it said on here, this memorandum of agreement. He went and looked at it, and it said it had something to do with the school district, and it said to see the agreement you had to go to a certain address. So he went to that address, and it was the high school. However, it wasn't actually the high school. It was close by, and they had changed their address, and so now they had a new address. So the district actually had an office, right? Just like the township hall's got an office, right? This school district has its own office, and they got a clerk, and they got people sitting on a board, and they got a president, and it's a political subdivision. It has governmental powers. And so he had to go there to get a copy of this agreement. It wasn't what the Register of Deeds even. It just, the thing in the Register of Deeds said there was an agreement, and this is where you would find it, in this other political subdivision. So, I don't know what that's all about. But that was just one thing. Now, what was some of the other things we found in here? School district agreement. Okay, this is the thing that was recorded. Dine Star Unified School, Maricopa County, a political subdivision in the state of Arizona, hereby gives notice to the public and any party acquiring an interest in the Royal Ranch Planned Area Development located in Surprise, Arizona, more particularly described in Exhibit A, attached hereto and incorporated herein, the property is subject to a donation agreement dated on this date. All the property is subject to this agreement until certain conditions have been met. The agreement is on file at the offices of the district located, and there is the address. And an acknowledgement. And this is the property that's over Exhibit A, and it's contains about 300 acres. It looks like 298.926 acres. Gotta look at something here. This is interesting. We're going to find some other ones that, whenever this says 3 of 4, right? This should be page 3 of a 4-page document. the way I see it, right? When you take something down and have it recorded, they put page one of, and however many pages there are. This one's got something on there. But all I'm seeing is 3 pages. 1, 2, 3. Where's the 4th page? Where's the 4th page? Okay. So, Dysart Unified School District, number 89, a political subdivision of the state of Arizona. A political subdivision all by itself. Its own self-functioning government. So that's what he found based on what his title insurance said would be there. And this took him to this school district where he got a copy of the agreement. We got to figure out what the agreement's all about yet. Then it said there was this party wall agreement. Okay, now look at this is a party wall agreement. It says 1 of 1, right? Yet if you look here, it's an 8-page filing. But all that was recorded was the first page, 1 of 1, party wall agreement. We're not going to read this. We're going to read what a party wall is, but right? So here's all this other stuff, and it goes on and on and on. Seals, exhibits. But basically what a party wall is 2 owners are going to say they're going to share a wall. Now what is a party wall? They're going to share a party wall, but it has lots of definitions. The thing is, this says 1 of 1, and there's 8 pages. As far as I'm concerned, they only recorded the first page. It's a error or an omission in a recording, and if you make an issue of it, they have to fix it. Or it's only the first page. You cannot say that this whole thing's been recorded. It says page 1 of 1. Which one has been recorded? Well, what is a party wall? A partition erected on a property boundary. That's interesting. The wall is subject to cross easements, reciprocal rights of use over the property of the other. Reciprocal rights of use over the property of another. The reciprocal rights of use over the property of another, right? These two people are going to make a agreement that they're both going to take your property. They're going to have rights over your property. Because of another doesn't necessarily mean the other party. A party wall is ordinarily created by a contract, and that's what we were looking at, party contract. Statutes authorize the construction of a party wall by 1 or 2 adjoining owners when the line between the properties is vacant, embodied the common law, and have been upheld, constitutionally valid exercise of the police power of a state. There's the police power. What is that got to do with anything? A party wall can also be created when the owner of buildings that stand on adjoining lots and share a common wall, which forms part of each building, conveys the lots to different persons. Okay, so that would be a party wall. When he conveys, share a common wall, which forms part of each building, okay, conveys the lots to different persons. Each owner acquires title to 1/2 the wall and an easement for its support as a party wall in the other half. So you get title to the wall, but you have to take care of the wall. This rule applies even though the deeds are silent concerning the rights of the parties in the wall. Now, right, it doesn't say what your rights are. That's in the contract that you didn't necessarily know even existed. The result is the same when one of the lots is retained by the original common owner. Okay, so if there's one common owner to all this property and then he splits it, but he keeps one lot, he just formed a party wall. The result is the same when one of the lots is retained by the original common owner. If the original common owner keeps one lot and does nothing with it, it's considered a party wall. And there's an agreement that has to do with an easement, right? So here's an easement that just came up. Wall built as a result of agreement loses its character as a party wall when the parties rescind or cancel the agreement. I think we need to run down and cancel the agreement. But there was never any agreement because it was never put in. Only page 101 was put in, which means the signature page never made it in. Okay. What else was there? Oh, they talked about if he was part of if he was part of a homeowners association. Where was that at? There we go. Any charge upon land by reason of its inclusion in this homeowners association. So guess what? We got a homeowners association document, a 50-page agreement, declarations and of covenants, conditions, and restrictions for Royal Ranch. 50-pager. One of one. All they recorded is the cover sheet. None of this other stuff was recorded. All this stuff about there being a frickin' there being an association doesn't exist. They did not record it. So if it's as it's recorded, because this says you're responsible as it's recorded in the office, well, I'm only responsible for the front page. I don't care about the rest of this stuff. I don't care what you people do. None of this was recorded. So they can't say, the point is now your insurance company can't say, well, you have these things, that you're responsible for. Well, no, none of them exist. But really that isn't the point. Your duty is to defend me in all suits, so I'm being foreclosed on, defend me. And then he was also, there's another one. Now, it had something to do with this warranty deed from 1954. All right, this is another one that's listed on the exhibit, and it's a warranty deed from 1954. It appears that his property could be in this description here. But the interesting thing, it says the liabilities and obligations existing or that may arise against said land by reason of its inclusion within Electrical District 7. So it's subject to being in this Electrical District 7. Well, I would say that's where your utility stuff comes from, out of the electrical district. We saw they have a school district. They also got an electrical district. I wonder if that's some kind of political subdivision. I wonder if it still exists. But this isn't a docket book, right? So this one said it was in a docket book, 1173, page 3. And sure enough, when you went there, boom, you found this document in here. And so this is in a judge's docket book. Different than being in the Register of Deeds office. This is in the circuit court clerk's office, basically. In the docket. And unfortunately, can't read what that part said. But this is for property in Arizona being done in California. I don't know how many witnesses you have to have for a foreign judgment, but basically that's what this is. And I see one here. Was acknowledged before me. Acknowledged before me. It's got a stamp on it. Got a notary public. All right, so it's got 2 witnesses from California, and it would be a foreign judgment. I wonder if a foreign judgment may have to have 3 witnesses on it. In other words, was this thing lawfully recorded? I don't care that it's been recorded. Is it a lawful document? So Bob's going to go down and figure out what the hell this says. But, again, somehow he's been made a party to this contract from 1954. Where for $10 in hand, for $10 and other valuable consideration, somebody dealing with this sole and separate property do hereby convey to somebody else Maud M. See, there you go, Maud M. They didn't use the Stanley J. They don't use your middle name. And they consider it with your middle name to be AKA, also known as. Second half of the taxes, grantee herein assumes and agree to pay, and then whatever it meant to be in this District 7, and then whatever this is here that we can't read. So these are all things that, according to your insurance policy, you're responsible for. I don't think any of them have been lawfully recorded. And again, instead of worrying what they might say, what they might do, you simply point out, according to my policy, it's your duty to defend against legal actions. Start defending. And if they say, well, you're a party to all these different things here and here, and you say, well, is that your testimony? If that's what you're going to give me as your testimony, I need that in writing under your seal, because I'm going to have to give that to the judge and say, Judge, I have insurance, yet my insurance policy company is refusing to defend me. I've hired an attorney, and they have a duty to defend me. Judge, what are you going to do about it? Cool. All right, so that was that one. Look at one other one here. Where was Tom's? This is Tom and Tom Chapman, actually. Good man. South Carolina. This is his policy. Well, somewhere on here, on these few pages, it says this isn't your policy, right? So, but this is what it's supposed to have. It's supposed to have an owner's coverage statement. That would be page 1. It's got company duty to defend against. That's on page 1. Schedule A is an insert. Schedule B is an insert. Exclusions are on page 2. Conditions on 2 and 3. I don't know if an insert counts. Right? An insert's just something you stuff into something else. It isn't part of the original thing, so I don't think it's part of your contract. But, you know, that's the way they put it on here. And, okay, so what's covered? Someone else owns an interest in your title. A document is not properly signed, sealed, acknowledged, or delivered. Forgery, fraud, duress, incompetency. All that, you know, it's covering everything. Other defects, liens, or encumbrances. They have to defend you. Company's duty to defend against court cases. We will defend your title in any court case as to that part of the case that is based on covered title risk insured against by this policy. We will pay the cost, attorney's fees, and expenses we incur in that defense. We can end this duty to defend your title by exercising any of the options listed on item 4 of the conditions. Okay, we'll see what that is. All right. I'd at least call them and say, hey, I think you have a duty. Now, again, it talks about Schedule A and Schedule B. If that's the title of something, doesn't that need to be on the top? Right? This says owner's form. Eventually it says Schedule B. But if it's Schedule B should be the title, and then it should be owner's form, in my opinion. So I don't even think that this paperwork is lawful. And, you know, it's a list of the things that aren't covered. And again, you got all sorts of shit in books and pages, right? All these books and pages. Book 477, page 1008. Book 445, page 977. Book 538, 1262. Book 711 at 808. But wait, there's more. We got book 476, page 82, book 106, page 186, 451 and 1504. Cheapers. I wonder what all that shit's about. We got another one. We got Plat book 33, page 211. Right? How many people knew that they were attached to all these different instruments? Because I bet you none of them have your name on them. Schedule B of this policy consists of one page. Schedule B, extended coverage. Okay, if Schedule B is supposed to be extended coverage, how come it's exceptions from coverage? It says Schedule B is extended coverage. That's because I don't think that this is Schedule B. This is just the owner's form pretending to be Schedule B. Tricky. Well, then we got Schedule A, owner's form Schedule A. Again, I don't know, but got the name of the assured. It's Tom and Nicole. An interest in the lands is covered by this policy it's in fee simple. Title of the estate or interest in lands is vested in the insured. The land herein described is encumbered by the following mortgage, trust, deed. A mortgage from Tom Chapman and Nicole Chapman to Wall Street Financial. Well, guess what? Tom isn't on the fucking mortgage. So it doesn't matter. If that's the one you're looking for, I'm not on it. If Tom isn't on the mortgage, then, right? Then the one he's not on, they must be defending because this is, the one that they're saying exists. But Tom isn't on it. The land referred to in this policy is described as follows. Certain parcel of land, certain piece, parcel, or lot of land situate. Right? Now, as it turns out, a lot or parcel, I think it'd be a parcel. On Rose tax sale, they sold her parcel, and you look at how much acreage was involved, it says 0.00. It had nothing to do with the land. It was a tax sale of a parcel, and so the parcel isn't the land. The parcel is real property, maybe, or personal property. The lot is part of the address, and we were looking at the property tax form for Illinois, and it's when you transfer property. And one of the things that you could have checked instead of residential is land/lot. And when you look at what you got a lot, right? You didn't get anything residential. The legal description calls it a lot. So it has a legal description of a lot, and you're using it as a residential instead. Then we got exclusions. So it says, title records that give constructive notice in matters affecting your title according to the state statutes where your land is located. Title, ownership of your interest in the land as shown in Schedule A. And it was shown as fee simple. You must give the company notice of your claim. If anyone claims a right against you, your insured title, you must notify us promptly in writing. Send notice to the issuing office or send it to the claims department. Send it to the claims department. After you receive your claim notice or in any other way learn of the matter of which you are liable, we can do one or more of the following: pay the claim against your title, negotiate a settlement, prosecute or defend court case related to your claim, pay the amount required by this policy, take other action with which will protect you. Okay, the amount required by this policy, well, that was, the amount of the loan. The amount of your coverage. Okay, so they said that Tom and Nicole are both on a mortgage with this Wall Street Financial Company, but this was written to Nicole Chapman, and she's the only borrower. It's Nicole Chapman, doesn't have Tom on there. See the property address? 1 Bent Oak Court. That's the property address. Loan amount. Okay, so this has to do with the mortgage, and I don't see Tom's name on it. Closing will not be scheduled without a receipt of policy and paid receipt. Title insurance endorsement should read as follows. This is interesting, right? Closing will not be scheduled without receipt of policy. He's got the policy. Does he have a paid receipt? Did you get a paid receipt with your policy? Because closing will not be scheduled without receipt of policy and paid receipt. You got to get the policy and get a receipt for the policy. And here it is, and they didn't sign it. Look at that. There's an omission. Then you got some conditions. So here's the actual policy now. This is the title insurance policy. The state or interest in the land identified in Schedule A in which is encumbered by the insured mortgage is fee simple and is at date of policy vested in the borrower, fee simple vested in Nicole, shown in the insured mortgage and named above. The land referred to in this policy is described as set forth in the insured mortgage and identified as the property address shown above. Here the property address is 1 Bent Oak Court, Bluffton. Right, which I guess is the city. That's what they're saying is the property address. They're getting it with these addresses. They got mailing addresses, they got property addresses, they got land addresses, they got all sorts of addresses. Right? They get us with that. They get us with the way we put our name. They say that with your middle name, that's an alias. That is actually your first name, middle initial, last name. Otherwise, it's also known as. The policy consists of 1 page. Okay, so this policy, forget everything else you got. This policy consists of 1 page, including the reverse side hereof, which means there's nothing on the back, I guess. Right? Because that would be 2 pages. A piece of paper is a leaf and has 2 pages on it, page 1 and page 2. Unless an addendum is attached as indicated below. And they had one addendum, Exhibit A, and then they checked this box for endorsement, referring to the following state statutes, and it doesn't have any listed. SC, what the hell does that stand for? Referring to the following state statute. Environmental protection lien. They're going to put an environmental protection, they're going to put a lien against your property right off the bat. Now, I didn't see the ALTA endorsement indicated below are incorporated herein. Somehow you're part of an environmental protection lien, Tom. It's a lien on your property. But then in witness whereof, right? So this is lawful. You got the president and the secretary, and the secretary back in the day was known as the clerk of the secrets. And it's attested, and it's got the corporate seal. There you go. 1 of 1 with Exhibit A and whatever this endorsement is. I don't know anything about the endorsement yet, but now, I don't know if this was the back or not that Tom sent, but this said page 101, so I really don't care. 1 of 1. 1 page. And an Exhibit A, and that's this. All that certain piece, parcel, or lot of land situated lying between Bluffton Township, wherever it is, the above property is conveyed subject to all recorded restrictions, easements, affirmative obligations, options, covenants, as recorded in the Office of Registered Deeds, California. Okay, now this, see, now this has, I think that this is the one that matters, right? Because if there's any that you're part of, it's these right here. 447. This being the same property conveyed to Nicole Chapman. They didn't give it to Tom, so Tom was never part of the mortgage. Goes back to that first part they said. And it's recorded in a deed book. And then there's a tax map number. That would be interesting to look at. I want to see the tax map number. I want to see what this number represents. And that was prepared by somebody. Now this is Statement of Settlement Service Responsibility. We recognize we are responsible to reimburse you for actual loss incurred by you in connection with real estate transaction settlement services in which you are the seller, purchaser, leaser, everybody, prior lien holder, whenever such services are conducted by our approved attorney listed in the settlement agents, subject to the terms and conditions set forth below. So here's their settlement agent, right? And if he doesn't do right, then the company's responsible for it. Chicago Title Insurance. Failure of the settlement agent to comply with your written settlement instructions. Fraud, dishonesty, negligence of a settlement agent in handling your funds or documents in connection with such settlement services. It's exactly what they did. They did number 2. The transaction has never been properly closed. When it's properly closed, your deed is going to go to the county clerk, not to the register of deeds. It's going to get recorded in the office of the recorder in a different jurisdiction than the jurisdiction it's in now. And that goes back to where when Roe was talking to the treasurer, and he had mentioned, well, you recorded your deed. And she said, I didn't record it. Somebody else put it in there. And the guy said, oh, well, you can sue your closing attorney. And that's exactly what this is talking about, because there was negligence of the settlement agent in handling your funds or documents in connection with such settlement services. Right? And the company is saying, we recognize we have a responsibility to reimburse you for actual loss incurred by you in connection with real estate transaction settlement services in which you are the purchaser. Whenever such services are conducted by our approved attorney listed in the settlement agreement. So I don't know if this was Tom's closing agent or not at the time. I'm going to have to talk to him. But, they're saying that if he did something wrong, we're responsible. So, anyways, just a teaser on insurance. But, I can only tell what the paper says, right? And it says it. They have a duty to defend you. We have a duty to defend you. Where is that on this one? Owner's covered risk. Company's duty to defend. Page 1. Covered risk. Company's duty to defend. We will defend your title in any court case as to that part of the case that is based on covered title risk insured against by this policy. We will pay the cost, attorney's fees, expenses we incur in that defense. We can end this duty to defend your title by exercising any of the options listed in item 4 of the conditions. Where's the conditions page? That's exclusions, conditions. Item 4. Item 4. This is the conditions. I don't see an item 4. I see 1, 2, 3. Well, it says it's our choices when you notify us your claim. Okay. Well, this is 4 instead of the conditions. Okay. We can pay the claim against your title, negotiate a settlement, prosecute and defend the court case related to the claim, pay the amount required by this policy, take other actions which will protect you, cancel this policy by paying the policy amount, then enforce and only those costs, attorney's fees, and expenses incurred up to that time which we are obligated to pay.